The Maine statute is really unique. It has a dynamic definition of animals that's capable of being updated with the science. It says that animal includes every living sentient creature, not a human being.
Welcome to the Animal Law Podcast. I am so excited about this episode. Once again, we are joined by Asher Smith, who is, of course, the Director of Litigation at the PETA Foundation. And I invited Asher on because I had heard about this case about the Maine Lobster Fest. You might have heard about it, and of course, PETA's litigation regarding it. But then he also caught me up on what's going on in a case we talked about on episode 94 involving the University of Washington. And there have been some crazy good developments in that case. So we want to get caught up on that too. So we're going to do both. So we have a lot to talk about. So buckle up and welcome, Asher.
All right, thanks for having me again.
It's a thrill. I can't wait to hear about both of these cases. Just a quick reminder before we get to that, Rising Anxieties comes out on Tuesdays, the Hen Report on Thursdays, and the long form interview, including this one on Fridays. Bonus for Flock members comes out on Monday. We're a podcast and we're on YouTube. Please subscribe and hit like wherever you listen. Thanks. And okay, let's get started with lobsters. And as always, let's start off with some facts. Can you just pretty much tell us about the Maine Lobster Fest?
Yeah, sure. So, Maine Lobster Festival is an enormous attraction that takes place in Rockland, Maine. And what they do is literally steam 16,000 lobsters alive on public park land in a device that they refer to as the world's largest lobster cooker. It's actually up all year long. And what our lawsuit does is it argues that, for reasons I can get into, that actually does violate Maine cruelty to animal law.
Yeah, I really want to start with the cruelty to animal law, though, of course, since you're not the DA, that you can't directly just go into court about the Maine cruelty law, and you have found some really creative ways of highlighting Maine's really interesting cruelty law. So let's start with that first question. Tell us about the relevant parts of Maine's cruelty law, which really isn't that old. It was revamped, I think, not really long ago. But of course, specifically the very interesting definition of animal, which of course defines what the law applies to.
Exactly. So in one respect, the Maine animal cruelty statute isn't particularly unique in that it requires animal deaths to be instantaneous. It prohibits things like torture of animals. Where the Maine statute is really unique is that it has a dynamic definition of animals that's capable of being updated with the science. It says that animal includes every living sentient creature, not a human being. And that's so interesting because there are states where there's a large agricultural industry, and there we do see states that define animals for animal cruelty purpose based on species. We see states that don't count conduct that is generally accepted within a particular industry. Maine is one of the few states we've seen that actually allows who is covered by the law to be updated with the state of the science.
Yeah, and in a totally logical way. I mean, obviously, sentience is the whole ballgame when it comes to cruelty. It doesn't matter if an animal isn't sentient, whether you do something to them, and if an animal is sentient, like things that would be innocent in other cases, is obviously cruel. But of course, the term sentient is, as you point out, a moving target. And do you have any idea? Is there any legislative history about how they came to include this? Were they thinking in a particular way? Do they define sentient within the statute at all?
They don't define sentience, but sentience is, despite being a concept that is used by so many different fields of human inquiry, there really is a convergence on a basic definition of sentience, which is basically an animal or creature's capacity for consciousness and subjective experience, basically valenced experiences, that things can be good or bad for them, that they can feel pain and they can be aware of their own suffering. So that's fairly well established. And there's not too much in depth legislative history on how they wanted to define sentience outside how the relevant scientific fields might define it. But there is some super interesting legislative history and other statutory texts that sheds light on how this should be determined. Something that we've seen in our motion to dismiss briefing is the idea from defendants that, oh, this just can't include lobsters because lobsters are such a big industry here. They couldn't have meant that. And actually, what we can point to is the fact that Maine's cruelty code does, in sections that aren't particularly relevant for our purposes, but does have spots where it carves out lobsters, decapods for other reasons. So when they want to, they can.
Yeah, and also, even if, let's say they're right and the Maine legislature wasn't thinking of lobsters when they passed this statute, they used a word that would encompass change, and the science has changed since then, probably, or at least developed in very strong ways. So they they may not have deliberately included the word lobster, but they included a word that would have a shifting definition. I mean, unless they're stupid, that would be
You
a
know,
really dumb thing to do. They must have known that science changes, and this is essentially a scientific term.
it's really funny that you mentioned DAs earlier, because obviously DAs are the ones who are charged with interpreting the criminal code. And there have been local DAs in Maine who have confronted the question before of, wait, why can you do whatever you want to lobsters? Doesn't that violate our pretty clearly written animal cruelty code? And what they've tried to argue in the past, in opinion letters, things like that, is that, oh, actually, what sentience means is vertebrate animals. Vertebrate animals can be sentient, invertebrate animals, not sentient. And
Yeah.
that's just not
No.
how the science
No.
works. That's basically a
Right.
folklore approach to what is a dynamic scientific question. Scientists no longer believe, for example, that a vertebrate style brain or existence of a human like central nervous system is what's necessary to feel pain or
No.
have balanced experiences. Instead, scientists use, and this will be shocking, scientists use science. They look functionally at evidence of perception, behavior, learning, and lobsters, like other decapods, do everything you would expect a sentient creature to do. They avoid pain. If they feel pain, they'll rub themselves. Getting deeper into the science, they show all the biological distress markers you would expect for an animal that is capable of these kinds of valence experiences, like elevated lactate levels. And it's not really a case where we're expecting to go into this setting up a battle of competing, roughly equivalent experts on each side. Our view really does represent, and our complaint references the existence of hundreds of scientific papers. It quotes from a number of them. That this is rock solid science that other peer countries haven't just acknowledged, they've actually legislatively acted upon.
Hmm. Yeah, no, that is a ridiculous argument that it only applies to vertebrates. I mean, like, if they wanted it to apply to vertebrates, they could have said vertebrates. I mean, why would they say sentient? Uh,
Exactly.
all right. So one of the things they point out, which particularly annoyed me, is that they actually referred to one of the articles that you put in as, you haven't submitted all your evidence or had a hearing on this yet, but you've noted a few articles pointing out what you've just said. And they said that this article mentions it is doubtful if we will ever know for certain if they do or do not feel pain. And this kind of brings up a sort of standard of proof kind of issue. Like, how, what do the lobsters have to show? How strong does the evidence have to be? Does it have to be beyond all reasonable doubt or any doubt whatsoever that they are sentient? So I mean, obviously, this isn't a reasonable doubt standard. I mean, I don't know what the standard is. I'm not sure what it is. I guess that's why I'm asking you. But they're kind of arguing that if there's any doubt, then we don't have to worry about them.
Yeah, that's such a funny argument because it just shows a complete ignorance of how scientific inquiry works and how scientists will talk about their results. Scientists don't write like legislators, and that surely cannot be the standard here. As anyone who took science classes in middle school or high school knows, there's something called the scientific method. Scientists start out with hypotheses, they test their hypotheses, and they reach results that might have the impact of further confirming or supporting the hypotheses they started with. And you're not going to get a scientific paper that says, oh, I had an idea for looking into this question. The results are consistent with sentience. Game over. We're done here. We nailed it. Even papers that are literature reviews, they're going to accurately describe what is in the literature. And you can have really firm scientific consensuses that don't still produce a sexy soundbite in an academic paper that says, this is over forever. No one else can ask questions again. I think, again, I referenced before what other countries have done. Other countries aren't acting out of charity. I'm sure if you left it up to them, they would love to support local restaurants, their own local food industries, but they have seriously looked into these questions. The United Kingdom, for example, set up a commission that looked into the issue of decapod sentience, and they actually amended their cruelty law to incorporate lobsters in a way that it seems like Maine law is set up to do so. Other countries all over Europe, Switzerland, the Netherlands, Australia, Norway, have banned so many of the most torturous ways of
Mm.
killing lobsters exactly because of this evidence. Folks who listen to your show a lot might have mixed opinions about the conclusions put out there by the American Veterinary Medical Association. Um,
Obviously, there's some mixed feelings there, but when they say something
yeah,
good, that's good.
yeah. I mean, they're as far as you can get from animal rights advocates because that's not who pays their bill. But they also categorically state that because of what we know about lobsters, boiling unstung lobsters, which is very similar to how the Maine Lobster Festival kills them, is unacceptable.
Yeah, no, it does seem like a really strong argument. But unfortunately, as I said at the beginning, you're not the DA, so that's not the only argument that you have to win. And you have to figure out a way to, as usual, you have to figure out a way to get this argument into court. And the so even assuming you establish that the festival has violated the cruelty law, you still have a pretty long way to go. And so, but you came up, well, not came up with, you found a plaintiff who wanted to bring these arguments and had some causes of action that legitimately represented his or her particular interests. And you brought your, I shouldn't have said you found a plaintiff, you found a member, because we'll go into the associational standing. And you brought your suit in Maine Superior Court, which is the trial court in Maine. Sounds like an appellate court, but it's the trial court. And you have two causes of action, right?
That's exactly right. We have a cause of action related to the violation of the cruelty code, which results in what our member experiences as a public nuisance. We also have a violation of the public trust doctrine, which basically just says that Maine government entities are required to keep public intertidal lands in trust for the people that would use them. So, for example, PETA has a member that uses her kayak recreationally. And because what this festival does is by being such an imposition on the landscape of this public park, it makes so much of the park and surrounding area inaccessible for people like this member. Again, in the lawsuit, as you alluded to, what PETA does is it talks about one of its members who lives right by the steamer and finds themselves excluded not just from, say, their kayak launch, but also, you know, basic activities that you would use the park for, from participating in municipal life, basically, because this festival creates an illegal public nuisance.
Yeah, and so as always, you had to find a way that a human was injured, and you definitely did. And so you're suing as an organization. You're asserting associational standing, which means I think that you're suing, asserting the rights of your member. And they argue that you don't have standing because they don't know who this person is. Can you just address that briefly?
Yeah, that's a really interesting argument to see. They basically pull at some threads from various other First Circuit cases to argue that actually you can't have associational standing unless your complaint identifies the members who you're suing on behalf of by name. And that's just not the law either in Maine, in the First Circuit, in really anywhere. That's just not how associational standing works as a doctrine. The organization's job at each phase in the case is to do enough for the court to understand that there have been members who were injured. At the pleading stage, which is where we are now, the court has to take all of PETA's allegations as true, and that includes all of its allegations about the injuries suffered by PETA members.
So you basically laid out the way in which this person was injured, but let's get to the actual elements of the causes of action. I guess we can start with public nuisance. Um, and what are the elements of a public nuisance in Maine? And specifically, how do they relate to the commission of illegal animal cruelty?
Sure. So, something that you'll see across the country in many states is that public nuisance law is developed to bar, I think, paradigmatically, something like a brothel being located next to a school. You see precedent around public nuisance law use language around things that offend public morals. Um, Functionally, it's really the kind of thing we've litigated this in the past. For example, we had a case several years ago in the Fourth Circuit in the District of Maryland against a roadside zoo, alleging that their conduct against their animals was so egregious as to violate cruelty law and so constitute a public nuisance. And we've had traction with it in the past, which is that what the Lobster Festival is doing is so insanely torturous that it's a violation of Maine cruelty law and so egregious that it violates nuisance law. One thing I just want to make sure your listeners understand, because I'm sure many of your listeners are already offended by the concept of, killing lobsters at all to eat them. But they really, in order to facilitate this public spectacle, go about it in the most cruel way possible. It's a large logistical undertaking to literally steam 16,000 creatures alive. So they actually chill the lobsters beforehand um, to make them basically less active and make it easier for someone to pick them up and throw them into the steamer. Um, and on their website, it seems like they like to tell people that, oh, that actually makes it better. That makes it so much worse. What that means is by chilling the lobsters, they're actually sensitive to pain and take longer to die. They're really doing this in the most cruel way possible and prolonging their torture as much as possible.
Oh, it really is horrifying. Um, all right. So, public nuisance. The tricky thing about public nuisance, which sounds like such a great cause of action, is this requirement of a special injury. So it's public nuisance, but sort of not every member of the public can bring it, even if they're all injured, which seems kind of crazy. But I think this is pretty standard in public nuisance cases so they're arguing that, and they argue that this isn't illegal cruelty, of course, but they also argue that you haven't shown that your members have suffered this kind of special injury that is different from the general public. Um, and, and can you I mean, you've kind of alluded to that already by telling us where she lives and what she likes to do, but can you go into that a little bit about, because this seems to be a big argument on their behalf that even if this is a public nuisance, she can't sue because she's not specially injured.
Right. That's why those allegations that describe this member's activities, where they live, are so important. Because you're exactly right. It wouldn't be enough to say PETA has members in Maine, or even PETA has members in this county who would be effectively barred from the park because this is so disgusting. It causes them such distress. What we've had to do and what we've done in speaking to PETA members is we establish that they're people who actually are users of the park, that they do have a unique injury, that what's going on doesn't just injure them in the same way any member of the public who finds this disgusting might feel aggrieved, but that they are suffering that special injury, even if it's something like they can't walk their dog, they can't use their kayak, they can't participate in any festival activities because the world's largest lobster cooker would be looming over every activity that they would otherwise be undertaking.
So is the inability to reach the kayak, which you had specifically referenced before, is that a physical obstacle, or is it just the I shouldn't say just, is it primarily based in just how horrifying it would be to have to walk through this cruel spectacle in order to get there, or is this person actually blocked from using their kayak during the festival?
So what the complaint explains is that because the world's largest lobster cooker essentially dominates this entire landscape, the parts of the park that are in the vicinity of the cooker are effectively inaccessible for this member and others like them. So yes, that's basically how the kayak comes into play, is that they can't access their kayak without being basically right by the lobster steaming.
So I had jotted down this, and I'm not actually sure what I meant by it. I'm going to ask you anyway because I only have to ask the questions. The city also argues that it has no liability because it is just a regulator issuing a permit. Is that a viable argument?
I don't think that's a viable argument because the city is really taking a bunch of affirmative steps to put on this festival. They're the ones issuing the permits. They're the ones allowing their land to be used by this private festival corporation to do all this lobster steaming. It's not just that they're passively saying, "Okay, you applied for a permit, you can go." It's that the government is doing everything they can to promote this, to make it happen, to make it successful and accessible for people who want to go and steam the lobsters.
And that would, you actually have two defendants, right? It's the festival itself and the city. Am I right?
Exactly.
So even if the city were successful in that argument, and it sounds like it really does sound like a stupid argument to me here. I mean, they issued the permit. They couldn't do the festival without the permit. So that seems like liability to me. But even if they were successful on that, you'd still have a lawsuit. It just wouldn't be against the city itself. That's right.
That's right.
All right. All right. That's all I have on the public nuisance cause of action. Unless you have anything to add on it, I'd like to move on to the public trust doctrine, which is a cause of action I don't think that people are that familiar with. Um, and and here I saw from your papers that you argue that they violated the public trust doctrine by blocking access to intertidal lands abutting the harbor. It's already sounding very Maine specific because, I don't have any intertidal lands or anything. All right. So I, I'm not sure people understand what the public trust doctrine is or, its particular permutations under Maine law. So can you just kind of go into that? And because the interesting thing about it is that it's enforceable by private citizens, right?
That's right. And it is in many ways coterminous with what the public nuisance arguments are explaining. But Maine does, because Maine's shoreline is so precious to it, have a public trust doctrine that establishes that um, submerged lands and intertidal lands are held in trust by the state for the people who would actually be using them. You have to permit the public to actually use the land for fishing, navigation, things that they would use it for. And I mentioned the word navigation, but that's why this kayak becomes so crucial and really an interesting fact to develop because it might sound random, but it actually does bring the associational injuries in line with the paradigmatic kind of public trust doctrine that you would expect to see under Maine law.
Yeah, I think this argument gets pretty weedy pretty fast, and I don't want to get lost in I mean, probably literally in these weeds, considering the land we're talking about. But like it involves things like whether the festival takes place on wet sand or dry land, but the basics are that that at least some of the land that the festival is on is in the public trust, and the festival blocked public access to it. That's the gravamen of the cause of action,
That's exactly right.
right? That also seems like a good cause of action. Um, Maybe this question is a bit beyond the scope of this interview, but I'm not that familiar with the public trust doctrine. I may have run into it once or twice before. But do you think it's a promising avenue for animal law in other areas? It's kind of hard to tell because this is such a Maine specific. It's so geographically specific, but it seems like there might be a lot there of potential. As
Yeah.
the director of litigation for PETA, is that something you would have your eye on?
Oh, totally. Yeah. I think basically across all 50 states, especially as vehicles for federal standing become more and more challenging to meet. I think everyone who works in this field needs to be very attentive to each state's quirks of public nuisance law, that the precedent and in some cases statutory language will be different in each state, and whether there are other avenues like in Maine, this public trust doctrine. North Carolina has their 19A provision that permits for private rights of action to enforce cruelty law. We have some states that allow through consumer law the ability to argue that conduct that is illegal might also be actionable in some scenarios. We really do have to be attentive to all these potential tools to get at conduct against animals that, like you started off our conversation pointing out, would otherwise be up to local, potentially captured DAs to enforce.
Yeah, or DAs who just, aren't thinking like they're not out of the box at all. These are new arguments. I mean, people probably honestly did not think that lobsters were sentient. People didn't think that newborn human infants were sentient until relatively recently. So you can't be expecting everyday DAs who aren't interested in animals or theory about them to come up with these arguments or understand that the law is being violated. And they actually say, I mean, getting back to the basic cruelty question, assuming we're done with the public trust and public nuisance causes of action, I'd just like to go back to that they talk about how thousands upon thousands of Maine residents and visitors would be surprised to discover that they are now criminal animal torturers. I mean, I think that's a legitimate problem. People probably don't realize this, but how the legislature specifically made this a moving target of sentience, that it would move with the science. And we're always being told, well, by courts, well, we can't decide that. It's a matter for the legislature. If this is going to be changed, it should be the legislature, right? They passed this law. This is a matter for the legislature.
That's right. And that language that you just used to describe the law, a moving target, is exactly right. And what's so crucial to understanding this, I mean, that's the plain text meaning of this law. That's what the legislature set up. And it's so funny because on reply, after we pointed all this out in our motion to dismiss opposition, the argument we got from defendants basically tried to ignore that issue and just tried to say, aha, by your arguments, even scallops would be covered by Maine cruelty law. Isn't that ridiculous? And they completely ignore that no, it's a two-step analysis, and we just follow the analysis where the science leads. I don't want to prejudge any other questions having to do with other invertebrate animals or other animals that might lack a mammal-like central nervous system. But it so happens that the science as to decapods is very clear. I wouldn't rule out the fact that other species could one day meet that standard based on maybe methods of scientific analysis that we don't have available to us now. But right now, we have to deal with the scientific consensus as we find it.
That is such a classic comment. It's like, well, it's not up to Asher Smith whether they're sentient or not. It's not up to the DA whether it's up to science. And so the fact that it sounds ridiculous to us is just, meaningless. Like things change. It's, we think about this stuff all the time, but clearly they don't. Um, all right. That's kind of, I feel like I've covered the arguments, but if I haven't, let me know. You are currently awaiting decision, right? And we were a little worried that the decision is going to come actually before people even get a chance to listen to this. So that could happen. But have I covered all of the arguments that are now pending before the court?
There's one more really funny one I think your listeners might enjoy because defendants actually took issue with the length of the complaint,
Oh, I did
which,
see that. Yeah.
which is
I
not
didn't bother.
actually
I
that.
didn't bother bringing it up.
It's just so funny to me because it's not actually a particularly long complaint. It's about 30-ish pages. And what the complaint does is it is a speaking complaint. And it explains things both for the court and members of the public. Obviously, all court proceedings are open to the public, and we encourage people to be curious about what we're trying to argue the law should protect. And the complaint explains things like the state of the relevant lobster science, how that interacts with Maine cruelty law. And what they're copying, it's kind of funny actually, is an argument they saw deployed against Donald Trump in an 11th Circuit court.
Oh, right. Yeah.
If
Yeah.
yeah, if any of your listeners have practiced in the 11th Circuit, they have very idiosyncratic rules around what counts as overly verbose shotgun pleading. But they're using that to argue that, oh, if you do any more than the bare minimum notice pleading, that's not okay. But that's not how this works. It's our complaint. We're entitled to lay out our theory in detail, as long as it's all germane to what we're trying to do here, which is educate the court and the public about just how firm the scientific consensus is and just how egregiously the Lobster Festival's conduct violates Maine law.
Yeah. I mean, because their argument wasn't that things in the complaint were irrelevant or padding or. I mean, why would you want to make it longer than it had to be? It was just that it's just too long. That's so funny. Um, though, I think we should have sympathy, as animal lawyers. Not that I do this, but so that'll be up to you and others who actually practice. When you go into a certain jurisdiction, it's all new to them. And it probably does come as a little bit of a shock sometimes that we actually have good arguments and they actually make sense. It must be upsetting. All right, speaking of arguments, did you want to add something?
No, I was just gonna say it's exactly like you said. We have good arguments that might not be intuitive to people who've never thought about these issues before.
Yeah.
So that's exactly why we lay them out in the opening pleading.
Of course, of course. And as you pointed out, your argument is based on science and you can't just say it's true. You want to lay out some of the evidence for it. So you don't sound ridiculous to people who don't understand that the science is advanced. All right. As I promised in the beginning, we want to catch up on this case that you previously were on the podcast to talk about on episode 94. And I have down that I'm not sure how you say the title of this case. Is it PEPO 5 versus University of Washington? Is that how you say the caption?
Yeah, I think that'll work.
All right. It's weird. All right. I highly recommend that if you haven't listened to that episode, or it's a while ago, so if you've forgotten about it, don't recall it, that you might want to go and listen to it. But in case some people don't want to do that right now, can you just quickly recap what had happened so far when last we talked? I believe the case had reached the point of a preliminary injunction being imposed, and you were in the process of contesting that in the Ninth Circuit.
Sure. So I think the last time we had spoken, we had just gotten the second of, at that point, two Ninth Circuit decisions throwing out preliminary injunctions granted to plaintiff. Plaintiffs were members of the University of Washington Institutional Animal Care and Use Committee, who are responsible for approving every experiment that takes place on animals at the University of Washington, including at their National Primate Research Center. And what those initial Ninth Circuit decisions and preliminary injunctions focused on were basically issues under the First Amendment that plaintiffs argued they had a right to anonymity because they worked in such a highly contentious field. The Ninth Circuit dismissed with that pretty easily. That's just not how the First Amendment works. Second time around, we got it kicked on standing because actually pretty much all of these IACUC members' names had already been revealed to PETA or publicly through one way or another, including, amusingly, for these people who are trying to argue it would place their safety at risk. They disclose it themselves publicly in speaker bios, LinkedIn pages, and anywhere where it could be advantageous to them.
It
So
was,
that's
as I recall, the arguments were sort of ridiculous. And for those who aren't familiar, we're talking about the Institutional Animal Care and Use Committee, which is a setup under the Animal Welfare Act at places that do animal research. And these people who wanted to keep their identities secret. And their arguments were a little, I mean, as you just pointed out, they weren't great arguments by any means.
I think one that I highlighted last time was a through line throughout all their papers was essentially people call us Nazis. And what
No,
they,
this was classic. This was
yeah.
just
And,
classic.
and again, I can't stress this enough. I know I stressed this last time I was on. You are allowed to call government officials Nazis if
Right. Right.
If that's your opinion, the Constitution
Right.
protects that opinion. That
But
said, but actually, pretty much all the quotes they had referring to them as Nazis or making Nazi allusions was a kindly elderly retired former UW professor who shows up at the IACUC meetings to speak on behalf of the animals. And he wasn't accusing them of being Nazis. He was just reciting a famous aphorism by Nobel poet laureate Isaac Bashevis Singer to the effect that to animals, everything is Treblinka, is I believe how it goes. So that didn't fare them particularly well. But what we got after these Ninth Circuit decisions was they tried to have another go at it. We're in
yeah.
another court now, at another Western District of Washington court. And what they're arguing is basically that there's a constitutional informational privacy right to this information being secret, which is basically a kind of circular argument because they take steps to keep the information private. Therefore, it should be legally considered private and not public to disclosure if they could allege a risk of what they call harassment. They got a quickie preliminary injunction on that. We appealed to the Ninth Circuit again. And this was the very end of 2023, beginning of 2024. We won a Ninth Circuit decision where the Ninth Circuit just explained that that's not how informational privacy law works either. It's one thing to protect information like social security numbers or things that are paradigmatically sensitive. It doesn't extend to protecting just the mere fact that someone is employed in government service in some capacity. And if you'd like, I'd be happy to go a little bit into that in more detail and the next
Yeah, sure.
steps, because it really was fascinating to see how the Ninth Circuit received this. We got some help from the fact that one of the judges, Judge Lee, reached into the factual arguments a bit during oral argument and actually commented a few times that all these supposed examples of harassment were, it sounded a lot like protective speech. What, as a judge, I'm sure he's experienced is that this is more or less the price of public service. People are allowed to criticize you.
Right.
So
Criticism and harassment should not be the same thing.
exactly. And at that point, so we're back down to the district court now. They have to make a case of their remaining safety related theories. It might seem like a tall order given both the Ninth Circuit's decision on informational privacy law and the oral argument commentary on the other causes of action. They had one more trick up their sleeve. They actually canceled a meeting of their IACUC last December, saying there were now safety concerns. What was that? And this is where we kind of took a new tack with these cases. We tried a new strategy, which is instead of just waiting passively to see how they would frame arguments for a TRO and preliminary injunction, we told them, oh, okay, at this point, we need discovery. We need to investigate what you're actually experiencing. We need to understand this for ourselves. So we initiated this process of unilateral offensive discovery to figure out what happened there. And um, I mentioned before how examples of their claimed harassment and threats would fall apart. That's basically what happened here again. Um, a fact of litigating these cases is that we're up against institutions that start off with a lot of credibility with courts, with the public generally, with
Yeah.
media. It could take a lot to make courts skeptical of them. Courts before, in this case, hadn't wanted to engage with our factual arguments that essentially, come on, there's nothing to see here. These people are being histrionic and ridiculous. But we finally found smoking guns through this discovery, including things like their emails and Slack communications. And the reason they canceled the meeting was they got a very cryptic email from an anonymous member of the public that sounded like a kind of public records request asking for a roster of who sits on the IACUC. And what we found in their Slack is that in the process of ginning this up into something and saying, oh, this is the safety concern, we're finally at risk, is that the IACUC chair, who had previously been the one to submit all the prior declarations, explaining how scared they were, explaining the dire straits they were in a Slack message said, oh, now I'm a little scared for the first time, which our judge honestly seemed very annoyed by. He quoted
Well,
that
yeah.
Slack message and seemed pretty miffed that they had used his court for so many years at this point to pursue arguments that I guess in the past didn't leave them scared.
Exactly. Like, this is after years of litigation, this is the first time you actually are scared. When you've been arguing, you're scared the whole time. That is that would annoy me. It would annoy me.
Yeah, I mean, for federal judge speak, talking about fairly important government officials to say that the Ayakuk chair's declaration did not seem to actually correspond with reality is pretty damning,
Yeah, no,
honestly, and
that's
not
pretty strong language.
yeah, and if you'd be interested in where this went from here, we were able to use this going forward. Um, so at that point, we won the preliminary injunction. We had an entitlement to all the records that mention Ayakuk members that were being withheld as a result of the litigation. At that point, because there'd be no preliminary injunction, there really was no case in it for plaintiffs. The
Yeah.
information would be
Well,
released.
frequently, once you lose the preliminary injunction, you know it's over.
Exactly. So they agreed to drop that case after some more letter writing. We did get all the Ayakuk records that we were seeking. And after that, we actually wrote to them again. We wrote to the Washington Attorney General's office, who was representing UW in this case. And we wrote to them that basically, look, we're prepared to keep litigating this. Washington has an open meetings law that forbids meetings of government officials doing public business to happen in secret. We think, especially given the language of this preliminary injunction decision, plus all the Ninth Circuit commentary on this issue, there's no argument that what's going on here isn't paradigmatically newsworthy, that it isn't something that the public has a right to know, and any justification that member names could be secret during meetings or in their public records they're creating about these meetings, they completely fell apart if they ever existed in the first place. And lo and behold, within a matter of weeks, they totally surrendered that issue. The Ayakuk actually now holds their meetings fully in public. The names are revealed. The meeting minutes reveal the names. If you were to do a public records request for the appointment letters, the ones created now would use full names. It really is a complete and total victory because we were able to finally get the better of them in district court.
And could you go into a little about what you found out about the what might have been the real reason that they didn't want their names exposed, and who was on the Ayakuk? Because the Ayakuk has specific rules about who's supposed to be on it. And it's supposed to have non-scientist members and unaffiliated members. And can you just go into a little about who actually was or is on this Ayakuk under those classifications?
Sure thing. And that was really one of our theories of the case from the start. Aside from the fact that they don't want to be criticized, they think it should be illegal to criticize them, more or less. It seemed to us like they were really trying to make it impossible for the public to piece together the entire roster of the Ayakuk in any given moment, which is what's necessary to figure out if the Ayakuk is legally constituted. Like you mentioned, like I think we talked about a bit the last time I was on, institutional animal care and use committees are required to have several different specific members under NIH regulation and under legislation and as elaborated by guidance. That's a chair. They have to have a veterinarian. They have to have members who are sufficiently familiar with the science. They also have to have members who represent basic community interests in animal welfare. So, one way that regulation and guidance does that is by explaining the need to have a non affiliated member. The language NIH uses is actually someone with no discernible ties to the institution. So, they're not bound by a sense of institutional momentum or inertia to just rubber stamp things. And also a non scientific member, and that's where the legislative intent and the language of NIH gets so interesting because they really do suggest that in good faith, this is supposed to be someone with the language they use, literally a naive attitude about science. They suggest clergy members, lawyers, ethicists, Now, what UW does, and we were able to piece together at least a 29-month period between 2020 and 2025, during which, by the way, the IACUC had approved something like 1,500 experiments on animals, is that during those 29 months, all of their non-affiliated members, all the members they could reasonably argue would be non-affiliated or non-scientists, were insiders. That they were people who were either for non-affiliated purposes couldn't qualify, shouldn't be able to qualify because they were recent former employees, they were donors, they currently worked at institutions who had ongoing scientific collaborations with the University of Washington or the Primate Center, really far from no discernible ties. And the non-scientist story is actually all the more egregious. I mean, we know from discovery in this and other cases that this is an issue that nationwide and regional industry lobby groups for animal experimentation were super invested in and interested in. And it turns out that UW had been filling their non scientist positions with high level officials at the Northwest Association for Biomedical Research, NWABR. Folks might be familiar with NABR, which is the national group that served a similar function. For a while, still on the IACUC, their non scientist member, one of them was the executive director of this organization, who would literally, as his job, lobby for the public to
Unbelievable.
support animal experimentation at the University of Washington. Another non scientist member, also a member of the board at NWABR, and was actually for a long time the head of UW's Office of Animal Welfare. Nice name. But what that office actually was it was more or less the support infrastructure for the IACUC, what would basically tether the IACUC to the rest of the university infrastructure. So, not remotely ethicists, clergy members, people who come
Clergy
in with an
members. Their
open
suggestion
mind.
was clergy members. Yeah. I mean, it's so sordid, you can hardly believe it. And yet, the more you do animal law, the more you can believe almost anything. It's just extraordinary what you managed to find out. And, one can't help but believe that their very, very adamant insistence on keeping the identity of these people secret had may have had something to do with this. In fact, I think the last time you were on, before you actually had these names, you mentioned that you figured the committee might be stacked with insiders. Well, you're vindicated once again.
Exactly. It really is just so nakedly corrupt. And again, PETA's underlying motivation for all this was the UW is one of the most important institutions in the
Yeah.
country when it comes to animal experimentation.
Yeah, I'm not sure
Why?
people appreciate that UW is huge, huge in animal experimentation.
Exactly. And our question for the Ayacook was, why are they so bad at their job? What they had actually been cited before as serving basically as a rubber stamp. Actually, very recently, the Primate Center is a whole ball of wax by itself. PETA, before they had appointed a recent new head of the Primate Center, had pointed out, look, this person in her prior career at another institution was suspended for how she treated animals, how irresponsibly she handled care
My
of the
God.
animals
My
using
God.
her experiments, and they just covered their ears, didn't want to hear it. Lo and behold, within a pretty short period of time, that they actually have had to suspend that person from using animals at UW. That person is no longer the head of the primate center at UW because lo and behold, the exact same thing happened. She used animals in a way that they couldn't even sweep under the rug.
And you not only brought this to light and had these improvements made, but you're not just complaining about the future of the committee, but you're also going after some of the decisions that were made, or all of the decisions that were made, I don't know, while while these people were purporting to be legitimate IACUC members. Is that right?
That's exactly right. So I previously mentioned a 29-month period, and that's just the period that we're able to go public
Right.
with. Say we're 100% certain. We really don't think it was legally constituted during this 29 months. So for that period, we've written to HHS. We've asked them to claw back all federal funds awarded for those months, for those periods, terminate all the grants that the IACUC was responsible for during that period, retract published papers associated with those grants, suspend or defer the responsible institutional officials, and impose civil penalties on the
Yeah.
university or any people who are responsible for this. Because again, it's not just, oh, you didn't follow these regulations, but part of what the UWI Cook has to do in order to get its operating grants from the federal government, literally the grants that keep the lights on at the primate center, is they have to affirm that they have a legally constituted IACUC. So it's also affirmative misstatements to the federal
Yeah.
government saying, nope, everything's hunky dory here. Our animal experimentation lobby group guys, yep, they're non-scientists. Yep, our former employees, donors, collaborators, they have no discernible ties. We're good.
Yeah. And how else would it ever, I mean, when you think of the amount of effort PETA had to go to bring this all to light, how, if they don't, if there aren't these penalties, even if they seem draconian, which they don't to me actually, but even if they seem draconian, how else will they ever reform if there's no real reason to? If you can just wait for PETA to do unbelievable amounts of unearthing and legal work, and then the only thing that happens is that going forward you have to obey the law. It's just so necessary that there be implications for having, when you think about it, like Congress passed this law, and all right, I'm not in the mood to say anything really nice about Congress, but they passed this law in good faith and put in these requirements because they knew there were issues here that people care about. And they required these unaffiliated members and non-scientist members so that there would be even-handedness. And they're just completely ignoring it. And if there aren't repercussions, they'll just go on completely ignoring it. So I really hope that is successful. And I'm sure like this case turned out to be, it just every time you lifted a level of it, more things emerged that were just truly shocking. And I'm so glad that all of your worst fears were. Well, I'm not glad that all of your worst fears were vindicated, but I'm glad since your worst fears were true that they actually did become vindicated. So thanks so much for doing it, Asher, and for all the work that Pete's doing, and for joining us today. Is there anything else you want to add, or before we go?
I just do want to emphasize that again, you mentioned what's going to happen to them. We really do hope that HHS takes all these steps and establishes there are firm consequences for this. But that's also why it was so important that these decisions establish, just as publicly available precedent, that all of this is stuff the public has a right to know. The public should be aware of what's going on in these universities, and these people should be subject to public criticism. If you are in this position and you are just rubber stamping the most egregious torture against animals, at the very least, you should face the friction of at public meetings of the IACUC, members of the public knowing who they're speaking to and making their voices heard and letting you know this isn't animal welfare. This isn't what the law is meant to require, and it's not how they should be doing their jobs.
Yeah. Absolutely. Well, two amazing cases. Thank you so much for breaking them down for us. We'll be looking forward to hearing what happens next, especially in that lobster case, which should be soon. You'll get a decision on that. Well, of course, I mean, it might go on for quite a while after that, but you'll get that preliminary decision soon. And for those of you out there, just please remember that we're in our end of year fundraising effort. And right now we have an amazing match so that all listener donations will be tripled. And if you're not already part of the flock, we would love it if you would join, or just any donation that you could manage. We would very much appreciate it. I know that times are hard for some right now, and we love to have you listen, even if you can't afford to contribute. But if you can go to ourhenhouse.org/support. And thank you so much of course, to Asher. Thank you for joining us today. And also thank you to Vicki Beechler, Jen Riley, and Akbar Khan for their help in producing the podcast. And thank you to you guys for tuning in.